Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Cerenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Cerenade. Also, check out their blog at cerenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody. Immigration news made historian Heather Cox Richardson's Letters from an American Daily this week, and many other news sources, in the form of the horrific story of Kilmar Abrego Garcia. Mr. Garcia fled the gangs in El Salvador at 16 years old and received withholding of removal in the United States, protection from those gangs and that country. But 2 weeks ago or so, as the Department of Justice attorneys stated in federal court, the U.S. apparently removed him to El Salvador due to a, quote, oversight, end quote. This despite the fact that Mr. Garcia has no criminal record, works full-time as a union sheet metal apprentice, is married to a U.S. citizen, and is the father of a disabled U.S. citizen child. And of course, he had withholding of removal from El Salvador. The U.S. government put him in that prison filled with Salvadoran gang members in El Salvador. Then the U.S. government's representatives went into federal court and argued that because he is no longer in U.S. custody in America, it is beyond the reach of a U.S. federal judge to order that he be returned. Astonishing, terrifying, and really the height of chutzpah. One of Mr. Garcia's attorneys is one of our own, Simon Sandoval Moschenberg, and I believe I've talked about him on the podcast before. He's reported as stating, quote, they claim that the court is powerless to order any relief. If that's true, the immigration laws are meaningless, all of them, because the government can just deport whoever they want, wherever they want, whenever they want, and no court can do anything about it once it's done, end quote. I suppose that would go for U.S. citizens too, right? Late this week, Thursday or Friday, that federal judge decided it was having none of it and ordered that the U.S. government return Mr. Garcia to the United States. Instead of doing that, it's being reported that DOJ will appeal. All while Mr. Garcia remains in a Salvadoran prison filled with the gang members that form the basis for his grant of withholding of removal. Take a deep breath, everybody. You know I'm happy to promo the pro bonos. Here's a great event if you're in New York or would like to be. The Safe Passage Project is proud to host its inaugural gala on April 30th at Tribeca Rooftop, an evening dedicated to celebrating its mission and impact. The organization's attorneys work all the time to navigate complex legal barriers and ensure that unaccompanied immigrant minors receive the protection they deserve. But they can't do it alone. Community support is essential. With just a few weeks left, now is the time to secure your spot and stand in solidarity with immigrant children, as some of the most important organizations, by the way, are shutting their doors because of the lack of federal funding. The gala will highlight the powerful stories behind Safe Passage Project's work, honor champions of immigrant justice, Professor Lenny Benson and Jojo Annabelle, and raise vital funds to ensure every child has the legal support they need to seek safety. Secure your tickets today and help make a difference at safepassageproject.org. Link as well in the show notes. Here's your cases. 3. Again. Our first case is Alvarez Mendoza v. Bondi, published by the First Circuit on March 31st, 2025. This case is about withholding of removal and continuances. Mr. Alvarez Mendoza is from El Salvador and entered the United States without authorization. He applied for asylum and related relief in removal proceedings. While El Salvador is currently all the rage for imprisoning alleged Venezuelan gang members, Mr. Alvarez Mendoza didn't have quite so much faith in that government and alleged a fear of persecution based on his particular social group defined as, quote, victims of gangs who give statements to police in pending criminal investigations, end quote. I suspect, based on this decision, at least how it's written, and the fact that withholding of removal is the only thing at issue for Mr. Alvarez Mendoza, that he has a criminal history. Unclear, though. Mr. Alvarez Mendoza was, however, stabbed and severely wounded in Chelsea, Massachusetts, by an MS-13 member in 2020, and he helped police in the United States afterwards arrest that MS-13 member. Then, when U.S. police released the MS-13 assailant, that assailant twice confronted Mr. Alvarez Mendoza, warned him about future cooperation, and threatened to kill him if he testified against him. That assailant was deported, quote, presumably to El Salvador, end quote, before Mr. Alvarez Mendoza could testify against him in the United States. What on earth do we do with this? What on earth? Immigration law is not really prepared, I'm not going to lie. In his own withholding-only claim, Mr. Alvarez Mendoza cited a, quote, Salvadoran law, Decreto number 1029/2006, Ley Especial para la Protección de Víctimas y Testigos, also known as Special Law for Victim and Witness Protection from May 11, 2006, with that citation. That law was enacted to protect, quote, victims, witnesses, and others who are involved in the investigation of crime or in judicial proceedings, end quote. And I apologize for my very horrendous Spanish accent. But a smart thing to do, citing to that law. After all, it is understood in much case law that when a country passes laws to protect groups of people, those groups are, well, considered groups. Mr. Alvarez Mendoza also, of course, relied on Henriquez-Rivas v. Holder out of the Ninth Circuit from a decade ago, itself relying on that law that I just mentioned and holding that testifying witnesses can very much be particular social groups under U.S. immigration law. An immigration judge sitting in the First Circuit, however, denied the claim. Lots of reasons, including that, even if cognizable, Mr. Alvarez Mendoza wasn't part of that group. He didn't testify, remember? Though he did give a statement. The BIA initially vacated and remanded back to the IJ, but the IJ denied again. The IJ didn't like the particular social group and didn't like Henriquez-Rivas, stating, quote, it is First Circuit, not Ninth Circuit precedential case law that is binding here, end quote. The BIA affirmed that on lack of social distinction, and it all went to the First Circuit, which remanded back to the agency. The First Circuit believed that the IJ erred, and that the BIA erred in affirming that the proposed particular social group was not socially distinct by applying, quote, ocular visibility, end quote, as the standard, rather than social distinction. To be a particular social group, of course, the group must be immutable, particular, and socially distinct. And that social distinction phrase used to be called social visibility, but the BIA changed it about a decade ago, because as stated as social visibility, it could be interpreted to require that societies be able to identify groups with their eyes in order to be considered a particular social group. That's never been what social distinction or social visibility was supposed to mean. Quote, to be socially distinct, a group need not be seen by society. Rather, it must be perceived as a group by society. Society can consider persons to comprise a group without being able to identify the group's members on sight. End quote. That's a matter of MEVG. Here, in contrast, the IJ denied by stating, quote, as similarly discussed above, it is unclear how Salvadoran society could even measure or identify the victim who gave statements to police in pending criminal proceedings in the United States, end quote. And the above referred to by the IJ was the IJ questioning, quote, how Salvadoran society would be able to point him out, end quote. To the First Circuit, that sounded a lot like the IJ was requiring that to be a particular social group, a society be able to literally identify group members with their eyes in order to qualify. And that's not the law. So a remand. The First Circuit didn't quite believe that the IJ made other errors, though, but it remanded nonetheless, and as such, it believed that it need not truly resolve some of Mr. Alvarez Mendoza's other pretty important arguments. The most important argument made was about Henriquez-Rivas and whether the First Circuit would adopt it. The court was quite clear that it wasn't necessarily adopting Henriquez-Rivas, though. But on the other hand, the First Circuit stated, quote, this case is different from Henriquez-Rivas in at least two significant respects. One, the criminal proceedings in which the petitioner cooperated took place in the United States and not El Salvador. And two, the petitioner did not testify, end quote. And that's fair enough. But why distinguish the Ninth Circuit's Henriquez-Rivas decision if you don't think it was correct, First Circuit? Then again, the First Circuit brought to the parties' attention the very on-point and non-citizen adverse decision matter of HLSA from episode Forte, which involved a Salvadoran like Mr. Alvarez Mendoza and clearly sought to limit Henriquez-Rivas outside of the Ninth Circuit. Having highlighted both things for us, the panel noted that it is unclear whether the First Circuit will one day agree with Henriquez-Rivas, and sent the matter back to the BIA to possibly tee it all up for the First Circuit again. Who knows? The First Circuit does like to do stuff like this often, as regular listeners might be becoming aware. Having remanded for withholding of removal, the First Circuit said that actually, everything is back on the table for Mr. Alvarez Mendoza, including a continuance or administrative closure to await adjudication of a pending U visa. Indeed, on this quote, if the BIA were to fail to apply its own precedent and the analysis prescribed in matter of Sanchez-Sosa from 2012, such a decision would run the risk of being an abuse of discretion, end quote. Also, I believe that there might be some sort of applicable regulation on such things now too, that is with pending U visas and giving non-citizens more time. So rock on, Mr. Alvarez Mendoza. Also, the First Circuit notes that a withholding and a CAT claim can still lie, even though the harm and threats occurred in the United States. Although here it's most likely because the MS-13 guy was deported, and so it's not in El Salvador. But it's pretty interesting, right? Long one. Lots of stuff going on. And congratulations, Jacob Tuttle Newman, with whom Andrew S. Dolberg, Caroline N. Patterson, and their law firm Wilmer Cutler Pickering Hale and Dorr, LLP, were on brief. If you weren't already subject to an unconstitutional executive order targeting lawyers, I'd say watch out, Wilmer Hale. Good on Wilmer Hale for not backing down and for fighting for the causes and the pro bono matters that they believe in and for not backing down. Did I say that already? I'll say it again. Good on Wilmer Hale for not backing down. Congratulations as well to Oren Nimni on brief for Rights Behind Bars on Amicus. And that is Alvarez Mendoza v. Bondi. Moving on to United States v. Cervenak, published by the Sixth Circuit on April 2nd, 2025. En banc. This case is about crimes of violence. And oh mama, we've got the full Sixth Circuit here, the en banc court, providing us with the knowledge. With the dissents, this is an 84-page decision, and it's not even in the immigration context. Heck, it's not even about the crime of violence definition that we use in immigration. It's not really relevant to immigration at all. Of marginal value, one would think. One would be wrong. But no, not only am I not doing this monster, I didn't even really read it. I mention it for two reasons. The en banc court states that Ohio robbery is not a crime of violence, including the type that we use in immigration. But that holding is actually from the 2022 decision United States v. Butts, which it looks like I didn't mention on the podcast. God knows how I missed that. I apologize from the bottom of my heart. Rarely do I make such a mistake. I must be behind with my research. Alright, I'll stop. Booty, 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 rocking everywhere. So anyway, while it's not breaking new ground, I wanted to highlight that Ohio robbery is not a crime of violence, including for the immigration context, and that's Ohio Revised Code Section 2911.02. As I haven't really mentioned yet, but you might have gathered, this is in the sentence enhancement context, and it regards crimes of violence, but it doesn't regard the crime of violence definition that matches the immigration one. However, even for that non-similar crime of violence, the categorical approach and the realistic probability test still apply, the same approach and test used in immigration. So even more important than that Ohio Revised Code thing is what the en banc Sixth Circuit said about the realistic probability test. Probably one of the reasons the court went en banc. Let me step back. See, for years I've been saying that all courts except the Fifth Circuit apply the realistic probability test in the correct way envisioned by the Supreme Court in Alvarez. It is a shield for non-citizens and criminal defendants, not a sword for the government. Criminal defendants and non-citizens can use the realistic probability test when the criminal statute text matches the definition of an enhancement or a removable offense to show, if they can find a case, that actually, at least one time, someone was convicted for doing something beyond the federal enhancement or immigration definition. That at least one time, the statute that looks like a categorical match was actually applied overbroad. So, for example, with crime of violence, the federal definition requires knowing or intentional physical force, right? Let's say you have an Ohio statute that, per the language of that statute, requires the knowing or intentional use of physical force. You'd have a categorical match, right? Well, if you're talking immigration, the realistic probability test would allow the non-citizen to point to his own case or another Ohio case to show that actually one time, maybe, again, in their own case, the defendant was actually convicted for accidentally, say, brushing a police officer with a feather. That wouldn't likely meet the federal definition for a crime of violence, and so notwithstanding the Ohio statute's text, the non-citizen would likely have been able to show that actually his crime isn't a crime of violence. Even if the feathering of an officer happened in somebody else's case, it would have shown that at least one time there's a realistic probability that the statute can be applied overbroad. And in addition to that application that I just mentioned, I guess, non-citizens must also find a case applying the statute in an overbroad manner, even if the text of the statute is overbroad. In immigration, that is, even if DHS has the burden on removability, and even if the statute at issue clearly covers more conduct than does the federal removable provision, the non-citizen still has to find a case. Flips the realistic probability test on its head. I've been saying for years that the Fifth Circuit's an outlier, the only circuit to require this application. But I've hedged in the past as well, given Russell Bruton's belief that actually, things aren't so straightforward in the Sixth Circuit. There are definitely cases applying the realistic probability test in the Sixth Circuit in the manner applied by all other 10 circuits and excluding the Fifth Circuit. But Russell has also shown me cases where, actually, it's not so clear what the Sixth Circuit believes about the realistic probability test. But now it's clear, said the en banc court here. That was a long way to get to that holding, right? Sorry, guys. Rejecting the government's argument, the en banc court states, quote, "A defendant need not provide case law when they can point to the text of the state statute. We cannot ignore the statutory text. Thus, whereas here a statute's meaning is plain, the defendant need not provide a case to demonstrate a realistic probability that the statute is broader than the generic offense." End quote. The Sixth Circuit goes on to explain that, quote, "The plain language of a criminal statute can demonstrate, like in this case, that a state would apply it to a broader swath of conduct than the generic definition. On this point, we are in good company," end quote. The Sixth Circuit then cites to 9 circuits, but I think it's 10 because I think it includes the DC Circuit. The Sixth Circuit is officially off the board, leaving only the Fifth Circuit as the last circuit standing for its weird application of the realistic probability test. For all of you poor unfortunate souls in the Fifth Circuit, and who wish to walk on land, pages 13 to 15 explain in detail why the Fifth Circuit's reading of the Supreme Court's Duenas-Alvarez decision is wrong, without, of course, calling out the Fifth Circuit by name. Can't get a panel to overrule another panel in the Fifth Circuit or any circuit, but seriously, set it up for en banc rehearing in the Fifth Circuit, folks. Great excuse to travel to New Orleans. Heck, maybe try to get a panel in the Fifth Circuit to overturn the first Fifth Circuit panel that went astray, based on the latter decision from the Supreme Court, Mullooly v. Lynch. Arguments to make on that in footnote 5 of this decision. Seems like Judge Graves is on board, based on his concurrence in the pretty rough for non-citizens Alexis v. Barr decision out of the Fifth Circuit way back when on episode 7. And the Sixth Circuit notes that too. So there you go. Russell can finally sleep easily wherever he resides in Michigan. And you know he knows about it. He sent me this decision like 10 minutes after it was published. Thank you, Sixth Circuit. And that is United States v. Cervenak. Are you fighting like a maniac? Completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMREVIEW2025. Keep up and join the good fight. Concluding with Mathin v. Mayorkas, published in the Middle District of Florida on August 16th, 2024. It was a short week again, so it's time to dip down to a district court decision again. A very long one. This one published in the Fed Supp, so a little more persuasive than a not reported district court decision, right? On a naturalization issue over which the 11th Circuit has not yet spoken, in fact. And well, this decision is mine. Mr. Mathin's story is quite the saga. The complaint we filed in this case was like 250 paragraphs, so I certainly can't do it justice here, but to summarize, Mr. Mathin's parents were born in India, but in 1965 his mother and father traveled to Chicago on business. Mr. Mathin's mother was very pregnant during this trip. Mr. Mathin even eventually obtained a photograph of her at the Chicago Zoo, showing her very pregnantness. Mr. Mathin grew up in India and Hong Kong, but has always maintained that he was told by his parents at a young age that he was born in America. According to him, his mother went into labor during that trip, and a midwife assisted in the birth at a home. That birth was witnessed by multiple people, including the man who invited Mr. Mathin's family to the United States on business. And so, in the early 1990s, now as a young man, Mr. Mathin embarked on a quest to prove his U.S. birth. He eventually obtained affidavits from that man and another woman who was assisting the midwife in 1965, and the state of Illinois issued Mr. Mathin a delayed U.S. birth certificate. No small achievement. Delayed birth certificate in hand, Mr. Mathin applied for a U.S. passport. And so began a 20-year attempt, 3 attempts actually, to satisfy the Department of State that he was indeed born in the United States. A delayed birth certificate and 2 affidavits are not sufficient to the Department of State, it would seem. It all eventually ended up in federal court through excellent counsel, not us, where it came out that the Department of State conducted a somewhat weird investigation in the 1990s and made a fairly sloppy fraud report, which had haunted Mr. Mathin behind the scenes ever since. International depositions of family members and domestic depositions of State Department officers were taken, and lots of evidence was submitted. But a district court judge ultimately determined that Mr. Mathin had not met his burden. The Seventh Circuit affirmed by published decision, Mathin v. Carey. Check it out. During the appeal, though, and with opposing counsel's knowledge, that is, the Department of Justice, Mr. Mathin pursued adjustment of status. After all, he had a U.S. citizen wife. Still does, with 2 very impressive U.S. citizen children, by the way. Shortly after he lost his Seventh Circuit appeal, USCIS in Chicago adjusted Mr. Mathin to lawful permanent resident status. Wouldn't you know it? And the best fact of all, in the green card, they listed his place of birth as USA. Can you believe it? He did, after all, have that delayed Illinois birth certificate. By the time he decided to naturalize, however, he was living, at least some of the time, outside Orlando. And when Orlando got his application to naturalize, well, I don't think they had any idea what to do. They initially denied, stating, get this, that he was already a U.S. citizen, given the place of birth notation as USA. They held fast to that on the N-336 administrative appeal, forcing Mr. Mathin to sue in federal court. He did so in the Northern District of Illinois. USCIS then asked for a remand, though, which the judge granted, and USCIS then threw the book at Mr. Mathin. Fraud, false claims to citizenship, even illegal voting allegations. Kind of weird, though, right? Because he still had that Illinois birth certificate? It all got very complicated. And that's where our firm came aboard. Notices of intent to deny and a new N-336, and we were back in federal court, now challenging USCIS's massive naturalization denial. Ultimately, USCIS took the position that Mr. Mathin had failed to disclose in his adjustment application that he was arrested in a Department of State office in 1996, something that allegedly occurred when he first applied for that passport, and which USCIS had records of, from the passport litigation, so totally knew about when they adjusted him. Might not have ever even happened, though, too. It's complicated. Read this decision from the Middle District of Florida for an unbiased version of the facts, people. I can't pretend neutrality on this one. USCIS also alleged that Mr. Mathin was not last inspected and admitted when he entered the United States, because at his last entry he presented his delayed Illinois birth certificate, which I guess they were alleging was fraudulent. That's complicated too, but without an inspection and admission, you can't adjust LPR status. Meaning that Mr. Mathin didn't properly adjust, meaning he can't now naturalize. Between you and me, listeners, that's hogwash under the law. A claim to citizenship at the border is only an adjustment barring non-inspection and admission if it's made knowingly false. And when Mr. Mathin did it, he was literally litigating his U.S. passport eligibility and had a valid Illinois birth certificate. Finally, though, USCIS alleged that Mr. Mathin had voted 4 times and that he hadn't disclosed it in his adjustment of status application. Mr. Mathin vehemently denied this. And I'm not going to lie, this one was interesting to me. Is an adjustment of status applicant inadmissible or a naturalization applicant ineligible if they vote in a federal election, but they legally registered using a literal U.S. birth certificate that they believe is correct? It's an absurd question because it never comes up, but here it is. Because after all, there are millions of Americans who have no proof of U.S. citizenship and thus eligibility to vote beyond a birth certificate. So obviously the U.S. system presupposes that you can rely on a U.S. birth certificate to vote, right? Loved the legal question. Personally, I thought we had the better arguments. I would though, right? USCIS didn't have admissible evidence anyway that Mr. Mathin voted, so I don't know what would have come of all that. Along the way, we're pretty sure that USCIS pressured Illinois to cancel Mr. Mathin's delayed birth certificate. No proof of that, I admit, but the birth certificate is now canceled. Wild case. Once it came back to the Northern District of Illinois, USCIS, through its counsel, moved the judge to change venue to the Middle District of Florida, which we fought. And that dang motion remained pending, ripe, for nearly 2.5 years. No shade on the Northern District of Illinois, but that is an absurd amount of time for a venue change motion to remain pending. We tried all we could to get a decision, which we did in February 2024, where the judge changed venue to the Middle District of Florida. I'm still bitter about that. 2 months later, USCIS got a bit cute and NTA'd Mr. Mathin, initiating removal proceedings, which USCIS's counsel, the Department of Justice, then tried to use to move to dismiss Mr. Mathin's naturalization action 4.5 years after he had filed suit and after the U.S. government had already answered the complaint. And that, my friends, is what this decision is about. LPRs have a statutory right to sue in federal court if USCIS denies their naturalization application and the N336 appeal. They get de novo review by a federal judge. The federal judge determines if they are entitled to naturalize or not. At the same time, though, INA Section 310C reads as follows, and listen carefully. Quote, "No person shall be naturalized against whom there is an outstanding final finding of deportability pursuant to a warrant of arrest issued under the provisions of this chapter and any other act, and no application for naturalization shall be considered by the Attorney General if there is pending against the applicant a removal proceeding pursuant to a warrant of arrest issued under the provisions of this chapter or any other act." End quote. So the theory goes, if DHS initiates removal proceedings against an LPR who's applying to naturalize, they can no longer have their naturalization application decided. Under the statute, that certainly seems to be the case with USCIS. If removal proceedings are initiated, USCIS cannot naturalize someone. But DHS, a party to a naturalization action in federal court, divesting a federal court of jurisdiction over that very case based on action by DHS, the party to the action, doesn't make sense to me. Also, of course, that statute that I just read states that no application for naturalization shall be considered by the Attorney General if there is pending against the applicant a removal proceeding. Attorney General in the INA now means DHS and USCIS and sometimes DOJ for immigration matters, but it obviously doesn't mean a federal judge. So, the correct argument goes. In this case, the federal district court judge denied the motion to dismiss. Surprising to me, there's actually a bit of a circuit split on some of what I just said. We'll get to that in a second. But the 11th Circuit has not yet addressed this issue. This district court judge issued a lengthy decision that should therefore be relied upon by all practitioners in the 11th Circuit district courts. The court denied the motion to dismiss for 3 reasons. The first was actually for the reason explained by the 9th Circuit in its 2018 precedential decision, Yith v. Nielsen. Mr. Mathin's removal proceedings were not occurring pursuant to a, quote, warrant of arrest, end quote. Remember that phrase from the Section 310C language that I just read? The INA, and certainly the regs, does state that a notice to appear is a warrant of arrest for purposes of the naturalization statutes. Although I wonder if that's even the case if it's a deficient NTA. Not going there. But then a DHS regulation also says that for these purposes, quote, a notice to appear issued under 8 CFR section 239, including a charging document issued to commence proceedings under sections 236 or 242, shall be regarded as a warrant of arrest, end quote. You know what's not listed, explained the district court? Section 240 proceedings. Regular removal proceedings. Only section 236 and 242 proceedings are listed. Mr. Mathin and the majority of people like him are placed in regular INA Section 240 removal proceedings. The district court held that under the DHS regulation, a notice to appear that kicks off a Section 240 proceeding doesn't qualify as a warrant of arrest. Ipso facto, INA Section 310C doesn't even possibly apply to divest jurisdiction. Again, following Yith v. Nielsen. I'm gonna be real with you though. I like the district court judge's next two rationales a bit better. Regulations aside, reading the statute on its own, as Loper-Bright requires, the district court doesn't quite understand how a notice to appear can be a warrant of arrest at all. There actually is a warrant of arrest provision in INA Section 236A. But that's not the same as the Section 239 NTA. Quote, a notice to appear is merely a written notice that shall be given in person to a non-citizen and which describes the removal proceedings, end quote. How is that a warrant of arrest? Asked the district court judge rhetorically, agreeing again with the Ninth Circuit. Quote, Congress clearly defined warrant of arrest as a writ that issues to arrest and detain a non-citizen, and is not the same as a notice to appear, end quote. The last rationale is what I like the best, personally. And in it, the district court agreed, in the alternative, that the statute's use of the word, quote, Attorney General, end quote, means exactly what it says it means. The Attorney General and the lower DOJ and DHS entities, but not a federal court. A statute that expressly divests agencies of jurisdiction to adjudicate a naturalization petition doesn't do so with federal courts too. That would be an extraordinary statute. No circuit has really agreed on that either, although it does get confusing with the Second Circuit. The government's real contention on this Attorney General phrase is something that there is a circuit split on. It's that a court can't grant relief to someone like Mr. Mathin, even if it does have jurisdiction. After all, if Mr. Mathin or people like him win in federal court and the judge says that he has satisfied the naturalization requirements, the physical act of making him a citizen must go through USCIS. And that is something that, per the statute, USCIS can't do if removal proceedings are ongoing, right? Assuming the warrant of arrest thing, of course. Sneaky. The best law on this for non-citizens might be out of the Seventh Circuit, where we got our venue changed from, if you recall. Non-citizens might have problems with this in the Second, Sixth, and Ninth Circuits. Here, the district court agreed with the Seventh Circuit. Quote, a declaratory judgment of entitlement to citizenship would not violate the statute, because it would not order the Attorney General to naturalize the non-citizen while a removal proceeding was ongoing. Instead, a declaratory judgment in the non-citizen's favor would bring the removal proceeding to a prompt close, allowing the Attorney General to naturalize the non-citizen, end quote. So people, make sure you ask for, among other things, declaratory relief in your federal court naturalization actions. Might save your client's butt for the United States down the road. Also, to the district court to hold otherwise seemed very unfair. Quote, to adopt the government's interpretation of these statutes would largely nullify the review afforded by the INA for naturalization actions, since the very review the court is directed to undertake could always be circumvented by the Attorney General by institution of removal proceedings and obtaining a warrant of arrest, end quote. The district court went on to explain why this was all further supported here by the significant delay that already occurred in Mr. Mathin's case and the fact that, well, the agency may have already made a bunch of errors. At this point, explained the federal judge, if anyone's going to get the first crack at these facts, it's going to be the federal judge, not an immigration judge. The court explained how the government had been giving Mr. Mathin the end run for quite some time through procedural and litigation posturing, and concluded as follows, quote, "The government's winning streak has come to an end. Win, lose, or draw, plaintiff is explicitly entitled to district court review of the Attorney General's denial of his N-400, and in this court, that right will be upheld." End quote. I literally jumped out of my seat and cheered. A longie but a goodie, no? And so congratulations, of course, to Mr. Mathin, Ira, the law firm, and yours truly on a heck of a case. If you're interested in hearing more about how Mr. Mathin's story concluded, shoot me an email. And that is Mathin v. Mayorkas. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.